months after that he had retired from being a veterinarian. That was what he had his doctorate in. He waited, and his testimony was that although his income had essentially, other than Social Security and other than some interest income, his income was completely gone after his retirement and sale of his veterinary practice. He did wait because he understood Miss Callaway had a mother who was going to be passing likely soon, and he waited on her to what he believed receive that inheritance from her mother before he filed this petition. He waited almost 15 months until the petition was filed from the time that he had retired. This court determined correctly that this was a reasonable and bona fide retirement, and that it was not done for any other purpose other than he was 72 years old at the time. At the time of trial, he was 75, and Ms. Callaway was 77 years old. This case essentially has to do with whether or not the trial court erred in determining that Dr. Callaway's expenses did not exceed his income. And the trial court really gave three reasons why it believed that his expenses were unreasonable. All of those, or two of those reasons, are factually just inaccurate on the face of the reasoning. The first one being that the court took judicial notice that Dr. Callaway presented a tax return in Exhibit 7 reflecting income in 2020 of $151,000. And as part of its reasoning that led to a finding of an unreasonable expenses by Dr. Callaway, it stated that essentially if you were to take that income in 2020, there's no way that it looked at on his original tax return, there's no way that he could have afforded the expenses that he listed on his income and expense statement. That discussion by the court really fails in two parts. One is did not look further at the amended tax return of 2020, which actually reflected income of much greater, of over $200,000. It ignores that. Secondly, it ignores the fact that people often have expenses that exceed their income. And it also ignores that Dr. Callaway had a spouse in 2020 who also had income, who had died 3 months prior to this hearing. She had almost $50,000 of Social Security and disability income that came in that he was no longer receiving by December of 23 when this case was heard. So with respect to that first issue, on the face of the document that this court is saying led to its unreasonable determination, that should be overturned by this court because the document actually does not say, the amended document, which should have been looked at, does not say what the trial court said. The second reasoning the court had as far as Dr. Callaway's expenses being unreasonable was based upon a chart that Dr. Callaway presented reflecting his veterinary practice, his self-employment income only. And again, the court looked at those numbers and said they're much too low. His income or his expenses on his income and expense statement are much greater than that. So therefore, these are unreasonable expenses because he was far exceeding what he couldn't possibly have expenses more than his income. Again, fails on these same things. First of all, the court misread Exhibit 4. It indicated that that was all of his income, but it wasn't. The statement itself says specifically self-employment income. He testified that was from my veterinary practice. In the years described in Exhibit 4, he was also receiving Social Security and did have some interest income in some of those later years. And so it does not include all of his income, and again, does not include his wife's income. And so on the face of it's just a clear misinterpretation by the trial court of his Exhibit 4, and that in fact his income was greater in those years, which then eliminates this, the reasoning of the trial court that his income didn't cover his expenses, and therefore his expenses are unreasonable. That was the second reason. The third reason the court gives that is just legally not sound is that his expenses are not the same as Ms. Callaway's and that they should be substantially similar to Ms. Callaway's. We have found the court didn't cite to any law. We have found no law that supports such a statement. This is 14 years after the divorce. Ms. Callaway, although the trial court anticipated that she would work, when it made the decision to give her the $1,750 and knew about her Social Security that she was going to receive, they also made a finding that she was still physically able to work. She chose not to. She chose to spend her life living in the home that she was awarded in the court with no debt on it and live off of her Social Security and this alimony for the next 14 years. So to say that Dr. Callaway, who continued to be a veterinarian and had a spouse, and Ms. Callaway never remarried, so, and Dr. Callaway did, there's just legally, there's nothing out there that indicates, especially in this type of post-divorce scenario, that their expenses should be similar. The facts actually were that Dr. Callaway had a house with a mortgage that was going to continue until 2041. He had a car that still had payments due on it. The maintenance on his home, he had described how he would keep Excel spreadsheets of his maintenance, how that had been fairly consistent. He included that number on his income and expense statement. And so it's our position that these determinations by the trial court of an unreasonable expenses by Dr. Callaway with nothing else more specific, there's nothing from the court saying, oh, this expense specifically on his income and expense statement is unreasonable, I'm going to eliminate that, or I'm going to eliminate this other expense. As such, we submit to the court that you have the same ability to review his income and expense statement, review his testimony, and review the cross-examination done by Mr. Sellers on those expenses and make a determination as to what, if anything, was unreasonable. This is a man who had, with the alimony, over $6,000 deficit. He admitted before he was even cross-examined that he had made an error on the income portion and that it should have included about $333 in interest instead of about $98. So he admitted that error. But even aside from that mistake, he still had close to $6,000 deficit where he was pulling from the sale of his veterinary practice in order to just pay his expenses, but also to pay the alimony to Ms. Callaway. It's our position that you have the same ability as the trial court to go back, read the transcript, look at the income and expense. There were no credibility determinations as to the way he testified or how he testified. It was merely based upon this document. And as a result of why the credibility determination was made, this court can look at that issue on its face again, because the document does not say what the trial court misinterpreted what the document said. That goes to our next kind of issue in this case, and that is if his expenses do far exceed his income, and each and every month he is using his assets to pay not only his expenses, but also this alimony, and most importantly, just the alimony. Simply if he has to pay alimony from his assets, it is our position that the case law reflects that is not appropriate, and that was really never addressed by the trial court. In fact, the trial court thought it would be fine if he could dip into that sum because his dipping in wouldn't be as much as her dipping in. But that's not the way the law reads. Alimony should be determined based on his ability to pay and her need. And at this point and at this juncture, it should be looked at equally, no longer the way it is at an initial determination. And the trial court stated that. However, I don't think the trial court followed that. Based on several cases that we cited, Bowman, Wilhoit, Ezekiel, all of those cases say if somebody is at a deficit with their income to their expenses, then there should not be an award of alimony given. Bowman goes so far to say that although in that case I think the party was going to work a little bit longer, that within a year the wife could sell her home. So that's kind of where we are here. This wife has a home that was awarded to her as I described in the divorce. At that time, it was $175,000 value in 2009. I think the court could take judicial notice was likely the lowest possible value of homes in the United States was in that year. It's on 6 acres. The testimony is that her first husband came back after 2009, would come to her home, work on that home nonstop, building a deck, the roof, painting it, clearing the land, creating ATV trails and walking trails, building a bridge. His testimony was that he absolutely added to the value of this home. Even just assuming incredibly low value of $175, she has assets too that she can use for her benefit and for her expenses. She has the home. Interestingly, the trial court also made an error in factual finding that she only had $76,000. This court took the inheritance amounts of each party and decided that it could take notice that they could get 4% interest in a CD on these accounts. But it only included the $76,000. It failed to find Exhibit 22 and 23 together reflect that she actually had $130,000 worth of investment-type assets. As such, that would, again, if you take the court's same reasoning, it would reduce her expenses by, I think, another $200, reducing it down to closer to a $1,300 deficit on her part when you look at her income and her expenses. But the reality of the situation is she has $130,000 to pull from, a house that she could either have a reverse mortgage on or sell, which she testified that she very well might do. It was 2 stories. She couldn't really live there without the help of her friend maintaining it, her first husband, and that her children were just waiting to live in a specific location. She was waiting for that time to move. So she can use her own assets, but I really want to take away from the court, or want the court to take away her own testimony about whose assets she should use to live off of, because there's no question she testified that she wanted to preserve her inheritance, and she wanted to use his inheritance to pay for her alimony. And that's in contradiction to what the law is. He does not have the income with his interest income and his Social Security, which is just a little over $4,000, to also pay her even the reduced amount by the trial court of $1,500. Thank you.
Thank you. You have your rebuttal. Yes, sir.
Good morning. Please the court, I'm Randy Sellers from the Bradley County Bar. It seems I've been almost as much with this court in the last 2 years as I have any time in my career, but be that as it may, here I am again. I represent Ms. Callaway. This is a case, as has been stated, that resulted from a divorce in 2009, and at that time, obviously Judge Sharp found that my client was a disadvantaged spouse at trial, and by the way, fast forward, found that she's still a disadvantaged ex-spouse, awarded $1,750 in futuro back in 2009. First, I want to point out, kind of jumping ahead, that I don't believe, and I don't think the record supports it, that the trial court based its ultimate ruling on tax returns that occurred 2 or 3 years before this trial, and tax returns that occurred when Dr. Callaway was still in active practice, except for reference as to a baseline of what that looked like and what does it look like now. Because at trial, his only income, obviously, as he said, was Social Security and some meager investment income. Social Security of $3,950 a month, and that's rounded. Interestingly, this court needs to examine Exhibit 3, which kind of became the focal point of this case. In my view, that's his income and expense statement. And you look at page 1, shows the income of $3,950 a month. He later testified he had some meager investment of about $300 or $400 a month. That wasn't on here. But then you look over at page 2 of that exhibit, and it shows a whopping expenses of $10,184 a month. And so I mentioned that at this point because he hasn't done anything in his retirement years to lower the expenses that he had when he was still in active practice, other than sell his practice and use that money, the $181,000 from the sale of the practice, to pay his monthly expenses that he couldn't afford on Social Security. Now, bringing it back to the pleadings, it's interesting to note that Dr. Callaway alleged in his pleadings, and by the way, he asked for a reduction or termination, not just termination of alimony, and he got a reduction. But he mentioned in his pleadings that one of the reasons Mrs. Callaway didn't need alimony anymore was that she had gotten an inheritance. Well, lo and behold, discovery reflects that he did too. But he seems to make that a focal point in his petition. As a matter of fact, she got an inheritance of about $184,000 to increase her estate. He got an inheritance of $585,000, not to mention his sale of the practice for another $180,000. So those are the facts that were out there. So both parties improved their position, but his was exponentially improved by the figure I've just given you. So At trial, we have two folks that have an income. My client basically has Social Security herself, which has been overlooked by Dr. Callaway, of a net of $928 a month. That's after paying Medicare and taxes, that type of thing. Dr. Callaway had income of $39.50 a month, plus this income from investments. The court basically looked at what each party was relying upon that they had in savings, and as counsel pointed out, came up with an imputed investment income from their respective inheritances and sale of the practice that could pay them income. And with that income, he found that Dr. Callaway still had an earning capacity of about $6,250 a month, not $3,980. And the court actually asked counsel after the trial was closed to agree on, if we could, what a proper interest rate would be for, I think, a 6-month or a 12-month CD. And this 4% number was what both counsels submitted to the court it would be reasonable. That's how that came about. He didn't just pick that out of the air. Now, the law obviously is state. Well, let me point out one other thing first. Counsel has properly called me on an error in my brief. On page 1 of my brief, I did state that Mrs. Callaway used her inheritance to pay off her mortgage. That's a mistake on my part. I did not catch that in my brief. What the court actually said is on page 4 of the trial court's ruling is that the court found that after Mrs. Callaway received her inheritance, she paid off, quote, several bills. And then the next sentence goes on to say, the court finds that she currently has her home paid for. So I misread the inference that it was paid for out of the inheritance. It is, in fact, paid for. You can look at Exhibit 24 and see she has no mortgage payment. And by the way, that's an interesting point because counsel and Dr. Callaway would suggest that to keep her from having needs, she should sell her home at 77 years old and I guess start over. And when you sell your home, you still got to live somewhere, and now she will have a rent payment or a mortgage payment if she had to sell her home. I don't think that's what the law intended. Again, I think it's very important to note that the court, we believe, based its ultimate ruling more on the fact of what Dr. Callaway had done to improve his estate by receiving this inheritance than it did on the actual incomes, although he did use the income generated from investing that same money to come up with its ultimate ruling. And as we know, that size of the assets that you have or separate estate is one of the factors from the statute as cited in my brief at 36.5.121, little parentheses I. Paragraph, of course, need and ability to pay, as we know by case law, and we've cited that case law, are the major two factors in awarding and modifying alimony. But we can't, it doesn't escape the fact that subparagraph 7 of those same factors says the separate assets of each party, both real and personal, tangible and intangible. So we believe he did focus on that somewhat in this case because it's a retirement case. Now, turning to retirement, and was that bona fide? Is that enough to modify? The standard that we're operating under is that, number one, we've cited this Malkin case, M-A-L-K-I-N, to indicate that the Court of Appeals is disinclined to second-guess spousal support decisions of the trial court. So what's the standard? It's abuse of discretion, and that would be reversed only when certain things happen. Number one, the trial court applies an incorrect legal standard. I think counsel in her brief agrees, or in her reply brief, that the court did apply the correct legal standard. She just says he misinterpreted the evidence. Number two, that there's an illogical result. Well, let's look at the result. Is it illogical? My client makes $928 a month in income. She's still disadvantaged. She's in bad health. She has diabetes. Her income is still 1/4 of what his income is by the court's finding, as it was when the court ruled on this case in 2009. The third element, was it a clearly erroneous assessment of the evidence by the trial court. The doctor argues that his income has obviously greatly decreased, but he is unwilling to, again, consider the lowering of his own expenses. In other words, if she has to sell her house, what could he do to lower his expenses of $10,000 a month? And by the way, that large of an amount of expenses gave the trial court great concern, that's words the court used, and question on his credibility as to what his income and expenses truly are. If you've got $10,000 over here, you say month after month, I have to have $10,000. Well, where are you paying it from, is what Judge Sharp looked at. So it wasn't an illogical result. Third, clearly erroneous assessment of evidence. I've already stated that. And fourth, that the reasoning caused an injustice. Well, again, his assets have increased with this inheritance by a huge amount of over $700,000, not to mention the sale of the practice. We can't forget that. The court found that he's actually paying his bills from his practice account when he was practicing. Now he's paying it from that same account. It's just that the funds in that account came from the sale of the practice. That's how he's supplementing his $10,000 a month in expenses. It's not he just can't pay them. He's paying them, apparently. Next, the court needs to look at whether or not the trial court properly modified the spousal support. I've cited the cases of Malkin, Bogan, and Givler that go for or stand for the proposition that if you retire and it's a voluntary action on your part, and in other words, it's bona fide, as the case law says, it says still retirement alone is not sufficient to modify alimony or terminate. And whether I cite one case or 7 cases, all of those cases next go to the statutory factors I've already mentioned under 365121 subsection I. And as you know, there's 12 factors, and I've gone through a few of those. The two most important are financial ability of the obligor to provide, and then secondly, the need of the party receiving. Again, but also factor 7, don't forget the separate assets of parties, as I've already mentioned. And factor 5, the physical condition of the parties. Heard nothing about Dr. Callaway's, medical status or whatever. My client has diabetes, has some other various ailments that befall persons that are more in their 70s than maybe their 50s, that type of thing. Also point out that the obligor in a case of termination or modification obviously has the burden of proof, and we don't believe that they carry that burden of proof. Again, I've mentioned that credibility was an issue. I quoted what the court said about having great concern as to Dr. Callaway's credibility, given what he claimed were his expenses that he's somehow paying. Credibility, I think I cited the case of Givler and Lindstay as to credibility findings not being reversible unless there is clear, concrete, and convincing evidence to the contrary. As to modification, the trial court properly rejected that this Mr. Cherry, who was a first ex-husband, was living with her. This was the same issue he brought up and attempted to prove at trial in 2009, and Judge Sharp didn't find any merit in it then, as he did not now. Although Judge Sharp, in his order, spent about 3 pages discussing all the factual reasons that negate any proof whatsoever that Mr. Cherry was a resident of Mrs. Callaway's home, or that Mr. Cherry was in any way paying for her expenses. It was an interesting bit of testimony. Mr. Cherry testified, and basically he talked about how bad he felt about what he didn't do for Ms. Callaway, which was his first wife, back before Dr. Callaway, over so many years, and he's just trying to make up. And also he's, in a position where he could come down and stay there, work on her house, do things for her. that type of thing. But again, we think that the trial court properly found that he was not in any way contributing to Mrs. Callaway's monthly expenses. So the bottom line is the trial court properly found that Dr. Callaway had the ability to provide support, which again remains 4 times greater than Mrs. Callaway. The court imputed income properly, we believe, to both parties. And it just belies, I guess, whether it's genuine or not, that Dr. Callaway argues that he should be allowed to retain his assets while Mrs. Callaway should incur new debt to provide for her monthly expenses. So we say that the modification by the trial court was not an abuse of discretion.
Thank you, sir.
Thank you.
Your rebuttal?
Yes, Your Honor. I believe that what we're asking this court to do is focus on her need. This is not a comparison case as to what their different expenses are. She provided her income and expense statement. The court determined that her total expenses were $2,750 per month. Then the court took into consideration 4% of $76,000. Even on the face of that, if you take exactly what the trial court did and add in the missing account that the court did not include, which is an extra over $50,000 of assets that Ms. Callaway has, this court must make an additional reduction of her need by about $200. So although this court did $1,500 at an absolute minimum, if you were to just use the trial court's reasoning of she's also going to have interest income on this other $50,000+, that's an additional $200 a month, which reduces her need down to $1,500. They would like us to do this comparison analysis of his assets versus her assets. That's not what I believe that this court has to do. The cases that we have cited say it's an abuse of discretion for a trial court to order a spouse to pay alimony in an amount that would create a substantial deficit for the obligor spouse. That's in Ezekiel. It was also in Cain Swope, and Floyd affirmed the trial court's refusal to award wife's alimony where husband faced a monthly deficit. So I disagree with Mr. Sellers. Just does go back to this issue of whether his expenses are unreasonable. Even if you look at the trial court saying his income should be $6,250, there are no specific findings as to his individual expenses that would say any of them are unreasonable. These are the expenses that he had coming into this trial and that he had had for several years. I mean, he had shown how he had been working at a deficit and having to pay both her and some of his expenses. And so, therefore, he doesn't have the ability to pay. The ability to pay does not mean go into your accounts and pull out the principal and start paying that as alimony. That's exactly the opposite of what these cases tell this court, and that is an abuse of discretion. So, yes, when it comes down to who should have to use their assets to pay the expenses, she should. She has assets. She has at least $130,000 worth of hard assets that are fungible, liquid, that she can use to start paying down, using to pay her expenses. The trial court considered that she would pay nothing out of that $130,000, essentially fully preserving all of her assets, and it's just fine that he has to spend his just because they're more. It's not fine. That's not what the law provides, and because there is no ability to pay by my client other than paying assets, we ask that you terminate the alimony award.
Thank you very much. I want to thank both the attorneys for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. If there's nothing further, the attorneys may be excused. Madam Clerk, will you recess court until this afternoon?